Good afternoon, ladies and gentlemen. Welcome back. My name is Rick Schultz. I'm a member of the Political Science Department, and my claim to fame is that when Jim Mallory ceased to teach the introduction of Canadian government, of course he had taught from 1946 at McGill to I think 1991, with his approval I took it over. I'm not sure, though, it was with the students' approval over the years, and I can assure you that, one, I don't dye my hair, but I am not staying around 45 years. Generations of students take impose much more damage than they did in Jim Mallory's prime. Anyway, what we wanted to do with this part, and it is because this is meant to be a celebration of Jim Mallory as one of the leading political scientists in Canada. And Jim represents a generation of, and I haven't been able to come up with the best expression for this, of non-specializing specialists. Because he really was a giant in the field of political science in a way and in an extension that the profession, certainly since I've joined it, has become, and the professoriate had become much more specialized. I like to describe to myself, to my students, in terms of the body politic, as a specialist of the left nostril. You would not describe Jim Mallory that way. He was a master and mastered I would think 3 or 4 of the most important fields in the study of Canadian politics. He left long-standing, lasting contributions to our understanding in those areas. The purpose of this panel was not to talk about his work, but in fact to talk about the major areas and the continued relevance of those areas of Jim Mallory's research. He was, as we know, a specialist on Parliament. He also was a specialist on the role of the courts, particularly the courts and the federal system, but in addition, he was a specialist on the federal system. His 1954 book, Social Credit and the Federal Power, is a continuing book that, in fact, we expect our graduate students, our doctoral students, to be familiar with. And that's, I think, an important contribution that he made. So he was, as I said, a specialist in so many areas, and we thought it would be a way of celebrating his contributions to political science by assembling a panel of I like to say mid-career, younger professors. That's much easier now at my age to say that they're younger professors, because most of them are. And so we have Christa Scholtz, who's going to talk about federalism. I'll introduce her in a minute. James Kelly, who was a specialist on the courts, one of the leading specialists on the courts and the judicialization of politics in Canada today. Is, I think, our third panelist, unfortunately, in an area that was central to Andrew's presentation to you on Parliament, is not with us today because her grandmother died on the weekend. And she was, I must admit, she made an exceptional effort to try and be here by trying to organize the funeral to be on the Thursday, and she was unable to do that. And then she explored every way of getting from Halifax to Montreal in time to be on this panel, but we could not do that. So as a result, we're going to have 2 presentations. And then I haven't used this expression before to the 2 panelists, but they're going to have memories of their doctoral defenses and their oral exams, because I propose to ask them penetrating, insightful, deep questions of the kind that professors like to ask because they know themselves incapable of answering them. And so that's what we will do for the third part of the presentation. Let me start then with Jim Kelly. I like to refer to him as my professional Irishman. I wanted to celebrate St. Paddy's Day for him, but he decided it was too late for me to do this. Jim is a professor, a full professor at Concordia University, a PhD from McGill University in political science. He quickly emerged as one of the leading students of the Charter and more generally of judicialization of politics. His first book, Governing with the Charter, was shortlisted for the Donner Prize, which is the most influential prize in the field of public policy in Canada. He has edited several books on judicial politics, and his most recent publication, co-authored with a political scientist from Queen's, is entitled Parliamentary Bill of Rights, The Experience of New Zealand and the United Kingdom. Just published last year, I believe it was, by Cambridge University Press. I have to tell you one story about Jim, almost paternal delight, because when his first appointment was at Brock University, and the Chief Justice was giving the convocation address at the university, and so the university asked Jim if he could be there in advance, even though he wouldn't take up his appointment. And this, in part, made his reputation, because when he was introduced to the Chief Justice, in front of all of the hoi polloi and the high politicians of the university, she said, "Mr. Kelly, I am very familiar with your work. I am reading 2 of your articles right now." And the rumor mill went around the faculty robing room at the time, and it was quite impressive. Anyway, Jim is going to talk about one of the important areas of James Mallory's research that continues and in fact has grown in importance since 1982 with the passing of the new Constitution and the adoption of the Charter of Rights and Freedoms. Jim?
Well, I'd like to thank the McGill Institute for the Study of Canada for the invitation to participate in this symposium on James Mallory, and I'd also like to acknowledge the family's presence here today. As the theme of the symposium is the state of our institutions, my remarks will focus on the Charter of Rights, the Minister of Justice, and the Parliament of Canada. Now, I think this is a timely theme, as the Trudeau government has indicated that the approach to the Charter of Rights by the Harper government will and must not continue. Now, in the mandate letter recently issued to the Minister of Justice, the Prime Minister has indicated that the Court Challenges program will be reestablished, which actually occurred in yesterday's budget, with $5 million for each of the next 5 years. The Minister of Justice has also been instructed to review the government's litigation strategy, which, quote, should include early decisions to end appeals or positions that are not consistent with our commitments, the Charter, or our values, end of quote. Finally, the Minister of Justice has been instructed to review and amend Bill C-51, which is the Anti-Terrorism Act of 2015. Now, although the government has focused on Bill C-51, significant bills introduced by the Harper government are of questionable constitutionality, suggesting that rights-based scrutiny by Parliament is in need of reform. Now, examples of these acts would include Bill C-2, which is the Respect for Communities Act, which creates an onerous legislative framework for establishing new safe injection facilities and departs markedly from the constitutional standard established by the Supreme Court of Canada in the 2011 Insight decision. Bill C-36, the Protection of Communities and Exploited Persons Act, which is the Harper government's response to invalidation of provisions of the criminal code involving prostitution in the Bedford decision. Thirdly, Bill C-24, Strengthening Canadian Citizenship Act, which allows the Minister of Immigration to strip Canadian citizenship from individuals convicted of certain offenses. And finally, Bill C-31, which is Protecting Canada's Immigration System Act, which removes the right of refugees on a safe country list determined solely by the Minister of Immigration to appeal their rejection of refugee status. Now, some of these acts are actually currently under review by the current government, but this does raise an important question. Given that the Charter of Rights is a constitutional document that is ultimately but not solely interpreted by the courts, how have governments managed to pass constitutionally suspect acts without much or any parliamentary scrutiny? Now, the answer is multifaceted, and because of time constraints, I'll focus on two and suggest possible reforms to the state of our parliamentary institutions in light of the Charter of Rights. The first that I'm going to speak about is the Minister of Justice's reporting duty under Section 4.1 of the Department of Justice Act. Now, this is an unworkable provision, and it is in need of reform. The second is the absence of rights-based parliamentary architecture at the committee level. Canada lacks the equivalent of the Joint Committee on Human Rights in the United Kingdom, or the Parliamentary Joint Committee on Human Rights in Australia. Both of these committees are tasked with facilitating parliamentary scrutiny of the ministry's legislative agenda. Now, before I consider these factors, I want to acknowledge what I am not discussing today, and that's the efforts undertaken by the Department of Justice to ensure that legislation is developed in light of the Charter of Rights. This is a highly institutionalized and effective process for the vetting of legislation. But the Department of Justice only provides advice to the ministry, which ultimately decides whether to proceed with constitutionally suspect bills. Now, under Section 4.1 of the Department of Justice Act, the Minister of Justice is required to review all government bills and regulations for their charter consistency and to report any inconsistencies to Parliament at the first convenient opportunity. Now, to date, the Minister of Justice has never reported under Section 4.1, despite the Supreme Court of Canada invalidating more than 50 statutes passed by Parliament since 1982. Now, this failure to report is surprising given the comparative Westminster context. Now, under Section 7 of the New Zealand Bill of Rights Act, the Attorney General has a similar reporting obligation. Since 1990, 72 Section 7 reports have been submitted, and 35 of these have involved government bills. And like the Minister of Justice in Canada, New Zealand's Attorney General is a cabinet appointment. So the question I'm exploring today is what explains the failure to report to Parliament in Canada in relation to the Charter of Rights? This occurs because Section 4.1 is unworkable, as it requires the Minister of Justice to perform two contradictory roles. First, as Minister of Cabinet, she's required to agree to government bills because of Cabinet solidarity during their development. And secondly, as Parliament's legal advisor under Section 4.1, the Minister of Justice must report incompatible government bills to the House once a bill is introduced. So essentially, Section 4.1 is a statement of incompatibility that would only be used by the most principled and perhaps foolhardy Minister of Justice, given the obvious career implications attached to reporting against a government bill by a cabinet minister. But I think this raises an important question that is both practical and constitutional. How could a Minister of Justice participate in cabinet discussions leading to the introduction of a bill into Parliament where, at the moment of introduction, the minister now decides that the bill is inconsistent with the Charter and reports to the House of Commons under Section 4.1 of the Department of Justice Act? Now, a Minister of Justice that reviewed a bill and concluded that it was inconsistent with the Charter briefed Cabinet on these inconsistencies and was unable to convince the Cabinet to reconsider such a bill would surely have to resign because of the conflict between individual ministerial responsibility and the collective will of Cabinet. But I believe there's a deeper problem in the Canadian context with Section 4.1. This provision requires the Minister of Justice to report on what the ministry is constitutionally prohibited from introducing under Section 52 of the Constitution Act. And that is legislation that is inconsistent with any provision of the Constitution. But it does lead us to consider the following. Perhaps it's the approach to this very standard of constitutionality and the duty to report that has complicated the charter certification process by the Minister of Justice. And in so, I refer to the recent case of Schmidt versus Canada. Edgar Schmidt was a retired Department of Justice official who was in the office responsible for Section 4.1 reports, who argued that the standard of disclosure was to a level to make it relatively useless. So what Schmidt revealed was that the Minister of Justice only reports to Parliament if there's less than a 5% chance that a bill will be found constitutional by a court. So this is not a credible standard, but this is the current and historical approach to Section 4.1 that largely explains the failure to report, and that's the duty to disclose. In a sense, if a statute has a 95% chance of being found unconstitutional, the Minister of Justice does not report. So what's the solution to this unworkable reporting duty that is, at its core, an attempt to ensure a transparent charter certification process? Are there practices in other Westminster systems that Canada could learn from and adopt? Well, the answer is yes. It is found in the United Kingdom and Australia, and I think the solution is rather simple. Although Australia does not have a national Bill of Rights, the Parliament of Australia passed the Human Rights Parliamentary Scrutiny Act in 2011. This act requires all bills to have what are called a statement of compatibility, certifying how a bill is consistent or inconsistent with recognized rights and freedoms. Now, a similar provision exists under Section 19 of the United Kingdom's Human Rights Act. So there's an important difference between the reporting obligation in Canada and those in Australia and the United Kingdom. In Australia and the United Kingdom, all bills are reported on because of the approach to statements of compatibility. The minister is required to indicate which rights are engaged and why the minister believes the engagement is a reasonable limit. And these parliamentary disclosures, on average, are about 7 pages of a justification. Now, I'd argue this practice should be adopted in Canada, and Section 4.1 should be revised from the Minister of Justice's duty to report charter inconsistencies to the duty to issue statements of compatibility when a government bill is introduced into Parliament. And I would argue that this is even more important when a government introduces a bill in response to a previous judicial declaration of unconstitutionality, as the Harper government did in light of the safe injection facility decision and prostitution reform. Now, statements of compatibility submitted by the Minister of Justice would take one of two forms. First, the charter is not engaged. Here, the Minister of Justice would report that a bill is compatible because it does not engage any charter rights. Few would likely take this form, as most legislation does engage the Charter of Rights to some degree. The only exception I could think of would be the Ministry of Fisheries, but I'm not sure that's not really the type of legislation I'm speaking about. The second statement of compatibility is the charter is engaged, but the limitation is reasonable. Now, many bills infringe rights and freedoms, but are ultimately supported because these limitations are considered reasonable under Section 1 of the Charter. Now, the vast majority of statements of compatibility would acknowledge this duality of charter certification, as they do in the United Kingdom and in Australia. Now, the second approach, I argue, is the most important, as it would demonstrate a government's commitment to charter transparency when a Minister of Justice reports the reasons why a government has decided to proceed with a bill that engages the Charter of Rights and Freedoms. And I think to myself, if this process had been in existence for Bill C-51, the Anti-Terrorism Act of 2015, the parliamentary debate may have taken a different complexion, and the ultimate outcome may have been different, despite the barriers pointed out by Andrew Coyne in his presentation. So what would be the value of these statements of compatibility? First, it could create an informed parliamentary debate on whether to proceed with a bill that infringes protected rights and freedoms. Second, it would require the government to defend its position before Parliament that the limitation is reasonable. Now, the temptation for any government would be to have the Minister of Justice report that a bill does not engage the Charter of Rights. This report would render a statement of compatibility little better than the present approach to Section 4.1, which is the duty to report charter inconsistencies. Now, the speech from the throne in December 2015 focused on greater transparency, as the Trudeau government indicated that it, quote, will not resort to devices like prorogation and omnibus bills to avoid scrutiny. Modifying the Minister of Justice's reporting duty to require a reasoned statement of compatibility is in line with this sentiment. More importantly, it would demonstrate the Trudeau government's commitment to approaching the Charter of Rights in a more transparent way than its predecessor. Finally, this would represent real change if the Trudeau government were indeed committed to such change, as outlined in its 2015 platform. I'm just getting my water. That's what that was for. Now, I want to talk about the existing architecture of Parliament and how this is necessary if we are going to have a fulsome charter debate. Now, despite the policy importance of the Charter of Rights, very few reforms have been instituted to accommodate it within Parliament. The only charter-inspired reform is the 1985 amendment to the Department of Justice Act that resulted in Section 4.1 and the duty by the Minister of Justice to report charter inconsistencies. Now, for a revised ministerial statement to have any impact on the parliamentary process, changes to Parliament's committee structure would need to be introduced in tandem to the suggested changes to the Minister of Justice's reporting duty. And what I'm arguing is what is needed is the establishment of a standalone parliamentary committee that first receives the statements of compatibility introduced by the Minister of Justice, second, scrutinizes these statements of compatibility, and finally issues an independent assessment of Parliament whether in fact the committee agrees with the report issued by the Minister of Justice. Now, in a sense, what I'm calling for is the establishment of a joint scrutiny committee on human rights. So with the exception of New Zealand, which is a unicameral parliament, the practice in the United Kingdom and in Australia has been to establish joint parliamentary human rights scrutiny committees of both houses. Now, given the current debate surrounding the Canadian Senate, why is it preferable to have a charter scrutiny committee constituted as a joint committee of both houses of Parliament and not simply a committee of the House of Commons? And I would argue that there are essentially three reasons why a human rights scrutiny committee should not be a committee of the House of Commons. The first is the normal composition of the House of Commons as majority government. The second is the rules governing the composition of committees under the Standing Orders of Parliament, which is committee membership based upon party standings in the House of Commons. And in the current Parliament, with the Liberals a majority government in the House of Commons, they therefore constitute a majority on every parliamentary committee. And the third is the intense partisanship of the House of Commons that would undermine the effectiveness of rights-based scrutiny involving government bills. Now, the most significant mandate that a human rights scrutiny committee would have is to scrutinize government bills. And this is the principal reason why a committee should not be located in the lower house of Parliament, where the vast majority of government bills originate and where the government dominates the Commons. Now, if located in the House of Commons, a standing committee would be under the control of the government, as a member of the governing party would most likely be elected chair, and a majority of the members would be from the government caucus. The natural inclination of this committee as constituted would be to accept ministerial conclusions on compatibility and would not engage in substantive review of the bill in question. Now, this is the challenge that any parliamentary committee faces, given that party standings in Parliament determine the composition of committees, and majority government is generally the norm in the Westminster systems that I've overviewed. Indeed, parliamentary committees are only as effective as their composition and tend to be less effective when a committee is chaired by a government member and composed of a majority from the government caucus. Now, would this joint committee be effective, which I think is a fair question? In a co-authored book with Janet Hebert, Parliamentary Bills of Rights, The Experiences of New Zealand and the United Kingdom, published by Cambridge University Press in 2015, we explored this very question. In this study, we concluded, unfortunately, that rights-based scrutiny had not been particularly effective in New Zealand and the United Kingdom. Similarly, in Bonfire of the Liberties, New Labour, Human Rights, and the Rule of Law, which was written by Keith Ewing, he discusses what he calls the futility of the Human Rights Act, which he attributes to the reality of parliamentary democracy. And this comes from page 2. It's a very good quote. "This is the problem of centralized power and executive dominance and the ability of governments with the support of the House of Commons to do pretty much what they want." We could easily make this statement about our own parliament and the centralization of power that undermines the effectiveness of those members outside of the ministry and perhaps those outside of the Prime Minister's office. Now, given that these assessments have, for the most part, been pessimistic, Why should we expect the Canadian experience to be any different? I would argue that there's a number of reasons why we can hope that the Canadian experience may be more successful. And the first is that Canada can learn from these experiences and design scrutiny committees that overcome the limitations experienced by Australia and the United Kingdom. Now, to do this, they'd have to buy my new book and read it, but that's the beginning, I think, of the solution. The most important is that the committee must not be based on party standings and should be chaired by an opposition member, as in the case of the UK Human Rights Act. Now, this suggestion is not far-fetched, and there is a recent and important example of a parliamentary committee in our present parliament that departs from the traditional approach to membership based upon party standings. Now, the Special Joint Committee on Physician-Assisted Death, which is constituted in the current Parliament, departs from party standings, as the Liberal Party does not have a working majority on this committee. And this committee has a composition of 16, 11 from the House, 5 from the Senate. There are 6 Liberals, there are 2 Senate Liberals, and it's interesting to see whether they will vote with the Liberal caucus. The point is, the committee is a joint committee. It is chaired by a Conservative from the Senate and a Liberal from the House. The most important point is the government is not in a majority. And it does have the ability to be an effective committee, I would argue, as a result. Secondly, in terms of why the Canadian experience may prove to be more successful than its Westminster counterparts, the Canadian Charter of Rights is different from any of these parliamentary bills of rights. It is supreme law, it is entrenched in the Constitution, and Canadian governments, for the most part, have attempted to design legislation that is compatible with the Charter of Rights and Freedoms. Third, the Canadian courts are provided with important remedial powers that do not exist in any of these bills of rights under consideration. The Canadian courts can declare acts of Parliament unconstitutional, can amend the Charter in areas such as equality rights through analogous grounds, and can fashion remedies that the courts consider appropriate and just in the circumstances under Section 24. Thus, the possibility of judicial invalidation, which does not exist in either Australia, New Zealand, or the United Kingdom, may convince a government to address parliamentary disagreement with a statement of compatibility and the bill in question. Fourth, the Trudeau government at least appears willing to extend political capital to reform the institutions of the Canadian state. We see this in the commitment to electoral reform. Now, Prime Minister Trudeau has indicated that his government will comply with the Charter of Rights in a substantive way and a collaborative way with the Supreme Court, and will respect the parameters established by the Supreme Court in regard to the Charter. Fifth, in addition to this political opportunity for substantive reform, the Trudeau government's approach to Senate appointments provides perhaps the best opportunity for the emergence of substantive rights-based scrutiny by a joint committee of both houses. Now, as of March 2016, Canada now has, for the first time, a large number of crossbenchers or independents in the Senate, and the new appointment process may result in a less partisan and independent body. The current standings in the Senate are Conservatives 42, Senate Liberals 26, Independents 20, and there's presently 16 vacancies. Now, with the appointment of 16 nonpartisan appointments to fill Senate vacancies, we do have a potential crossbench of 63 senators in a 105 chamber. And the work of Meg Russell in the context of the United Kingdom has argued that it's the presence of independent crossbench members of parliamentary committees that make them effective or can allow them to be effective. And we're perhaps at the cusp of a similar institutional characteristic in Canada. Now, setting aside the fact that the Senate is not elected, which is a big caveat, for the first time in many generations, the Senate can potentially perform its role independently as a chamber of sober second thought. As I've suggested, this would be to the benefit of rights-based scrutiny by a joint committee charged with reviewing reasoned statements of compatibility submitted by the Minister of Justice because of independent members on this committee from the Senate. I'd like to conclude by referring to Professor Mallory's continued relevance to today's discussion. Throughout his academic career, Professor Mallory addressed 4 issues and concerns about the state of our political institutions. The first was a concern about the lack of parliamentary oversight of the ministry. Professor Mallory focused on the increasing use of orders in council by the ministry, but his concern is relevant today, I would argue, in light of the near absence of parliamentary oversight of government bills in relation to the Charter of Rights. Secondly, in his writings, Professor Mallory called for a strengthening of parliamentary committees as a way to hold the ministry to account for its policy choices. And as I've argued, there's a need to implement and not simply strengthen rights-based scrutiny at the committee level. Third, Professor Mallory's concern with the pathology of Canadian politics and the growing concentration of power in the Prime Minister and the Prime Minister's office. Now, I would argue that the Charter of Rights has added to this pathology, and I would use the example of physician-assisted death to demonstrate this, and it's the example that Mr. Coyne referred to, where on a conscious issue, the current government initially indicated that Liberal members of Parliament, because it's a charter issue, must vote with the government. I don't see that any different than the use of law and order or national security by the previous government to demand adherence to the party line by its caucus. And so we think of the pathology of Canadian politics. My concern that I would have with the current government is the use of the Charter as a vehicle to deny parliamentary debate is adding to this pathology of executive dominance and control. And I would caution the government against invoking charter values as a way to deny parliamentary debate. Fourth, Professor Mallory's call for reform, but reform consistent with the principles and values underlining parliamentary democracy. So in this vein, I've considered reforms within comparable Westminster systems to be true to this condition. So in my remarks today, I've used these 4 markers to assess the state of our political institutions as they relate to the Charter of Rights, the Minister of Justice, and the Parliament of Canada. Of the countries and bills of rights considered, the Canadian Charter of Rights is the oldest document, and Parliament is the least reformed institution in respect to human rights and parliamentary scrutiny. Now, the current government has indicated that it is committed to real change. Statements of compatibility and a joint scrutiny committee on human rights would represent and would result in real change. Thank you for your time.
Thank you very much, Jim. Very thoughtful. Our next speaker is Christa Scholtz, and as I had to say to any new candidate for hiring in the department, there is no nepotism in the Department of Political Science at McGill. It's a different spelling. It's OLTZ and ULTZ, okay? Christa is an associate professor in the Department of Political Science here at McGill, and she's made a point of saying this. I'd like to she want to explore this. She was born and raised in Treaty 6 territory, Edmonton, Alberta, earned her bachelor's degree in a college associated with the University of Alberta, Master's of Arts from the University of Ottawa, and a PhD from Princeton University. And she researches and teaches in the department courses in terms of Indigenous politics and policy, Canadian comparative and Canadian politics, constitutional and federalism. And her article, Federalism and Policy Change, an Analytic Narrative of Indigenous Land Rights Policy in Australia, was shortlisted for the prestigious 2014 John McMenemy Prize, which is the award given to the best article published that year in the Canadian Journal of Political Science. And so I'm pleased to call on Christa to present.
Okay, thank you very much, Rick. Thank you very much for the invitation to speak to this symposium today. I am not brand new to McGill, but at least I've been there for a decade. And I have had the pleasure, of course, upon the other Professor Schultz's sabbatical, to have had the opportunity to teach Poly 221. So I think that there is a feeling that I'm walking in shoes that are quite large, both within Canadian political science and within the department itself. So I've been asked today to speak on a critical subject of Professor Mallory's work, and that is federalism. I am going to organize my thoughts on the question, do we have the institutions that we need? And so federalism, of course, looms large because as someone interested deeply in Canadian political science, if you didn't want to deal with federalism, you might as well just leave the room. Give up the game. I think federalism is just part and parcel of understanding the DNA of this place. So I'm pleased to speak to federalism in this way. I'll speak to the definitions, speak to the kind of commitments that we've already entered into just by the daily plebiscite that is living in a federal state. And then I want to talk to the question of, well, what is the balance that needs to be struck? There's centralized federalism, there's decentralized federalism, and there's nothing in the definition itself which gives us any purchase about which one is better, which is it that we need. Those decisions are made both politically, through our political institutions. They are also made through the judiciary, by the Supreme Court of Canada, ultimately as the referee of the division of powers. So in that discussion, I'll mention a few cases that I've been not obsessed with necessarily, but deeply interested in. I'll speak to the Chilcotin decision of 2014, the landmark decision where the Supreme Court of Canada has finally issued a declaration of Aboriginal title. I'll speak to, briefly, the Securities Act. You're like, what do these two things have to do together? The Securities reference. I'll also speak to the Senate reform reference. And in that case, I find myself in the, for at least me, curious position of agreeing with the former Prime Minister, Stephen Harper. So that's my agenda. So federalism, what is federalism? We've made this commitment to enter into a constitutional space where power is fragmented, where power is divided across at least 2 levels of government. And what is required here is simply a commitment that either of those levels of government are autonomous within at least some sphere of jurisdiction. That there is guaranteed some level of autonomy, but it says nothing about how much. So a federalist is quite right to say that a centralized, very centralized federation is still very much and meaningfully a federation, while at the same time someone saying the opposite, a very decentralized place, is also meaningfully a federation. We are committed to the principle that the division of power, this guaranteed autonomy, is good because it yields what? That it will yield a better public policy on average, net benefit for this place and these people. That it will yield better representation for this place and our peoples. That it will there will be a net benefit to the immense and important addition of a real layer of complication to political life. That its virtues will outweigh its vices. One of those virtues is supposed to be better policy innovation. We are supposed to, on net, get better policies because provinces can innovate. But Professor Mallory has also led us to think more carefully about those. And this is where I will cite from his landmark work on the federal power and the social credit, where he says, there are those who regard it as a happy feature of Canadian federalism that the provinces are laboratories of social experiment in which a part of the Canadian people are free to explore novel avenues of public policy. He, however, says, subsequently, laboratories in unskilled hands may lead to unheralded explosions. That the laboratory technicians to whom we entrust our public policies, our collective decisions, may often be someone cast in the image of William Aberhart. Quite the challenge. Federalism is complicated. Federalism needs to be managed. If you don't manage it, it will manage you. So how is this balance to be struck if the definition of federalism itself gives us no purchase, gives us no direction on what the proper balance is? What is the federalism that we need? Well, we can look to the political system. We can look to our political institutions. And here I'll quote a leading Canadian scholar on Canadian federalism and constitutionalism, Patrick Moynihan, who says that really the division of powers, we shouldn't really worry about it too much. Why? Because politicians can always do indirectly what they cannot do directly. So this says, and I think is an important always reminder to us to say that if there is political will, if there is at least a consensus on what is the federalism that we need, that the de facto federalism that politicians can construct, that it can be constructed, that what the division of powers says and what the court says is not the last word. It reminds us to think about bargaining spaces outside of the courts, and that de facto and de jure federalism are two different planes that we need to think about. However, as a caution to Moynihan, he also presumes that there are institutions that will regulate this bargaining, that there is always an ability to pick up the phone, to engage in ad hoc bilateral negotiations across governments. The difficulty, however, comes in when the issues that face us politically are multilateral, multi-sector, multi-issue, multi-government. In that case, what do our institutions look like? And I think there we've got a problem. In that respect, we don't have the institutions, the federalism that we need. I will, however, disagree again a bit with Mr. Moynihan. I think he makes us think that, well, if governments can always do indirectly what they can't do directly, we don't need to think about the link between the judicial and the political. It tells us that the ability to cooperate politically is not at all linked to what's going on in the court, that it is not at all endogenous to a de jure federalism. And I think that is going too far. I think that to understand what politicians do, we must also understand what courts do. And so now I will turn my attention to, or my comments to, the court, or at least the Supreme Court. Does the court have an answer itself to, do we have the federation that we need? What is it that the court has for itself? Can we discern from its writings, which is all we have, really? Can we discern from its opinions, its own theory about the role of the judiciary in supporting and creating the federalism that we need? Do they have a coherent theory? Can we actually discern that there's something, a story that's going on there? My answer is, well, they say, and they offer in many of their federalism decisions this following answer. This decision, these conclusions are justified because it will support a cooperative federalism. That what we are doing on this bench of 9 is to support the political system in creating the federalism that we need. But there's, at least to me, a problem in that almost any outcome is justified as supporting a cooperative federalism. Two different theories operating at the same time. So for instance, in the Chilcotin decision, again, a monumental decision where the court has said that the Chilcotin people in kind of central British Columbia, have a finding of Aboriginal title over a percentage, a relatively small percentage of the lands that they traditionally claim. The back end of their decision, they ask, well, what are the powers then of the federal and the provincial government over Chilcotin lands? What is the jurisdictional issues that now arise? Are Chilcotin lands federal? Are they provincial? Are they both? Their answer as to how this should play out is that we should expand provincial jurisdiction on Chilcotin land, that key doctrines of Canadian federalism are to be done away with in this case in order to allow for effective concurrency. This is a story that says that if we take away the fences, if we take away as much as possible the lines between that constrain provincial and federal governments, that what will happen is to create cooperation. Getting rid of the fences will allow federal and provincial governments to address create a more cooperative federal space. This is a theory that says that removing jurisdictional boundaries creates a more cooperative federalism. This is in direct contravention to the securities reference. So the securities reference was an attempt by the Harper government to create a national securities regulator in a division of powers which very clearly had securities regulation within provincial jurisdiction. The federal government was seeking really a concurrent jurisdiction or an expansion of its trade and commerce power in order to create a securities regulator. And the scheme that was proposed was kind of precisely what the vision of Chilcotin gives us, that decreasing barriers, allowing for effective concurrency, will allow the federal government to propose a regulator where provinces can opt in to create a cooperative solution for securities regulation in the country. Precisely the opposite is what the Supreme Court of Canada decided. In their decision of the securities reference, they said, no, cooperative federalism is not that. Cooperative federalism is when we keep the fences high and we keep the federal government contained. And that only then can a real cooperation exist, a real cooperative federalism. So there's two theories going on, as I see it, as I look at these opinions from the Supreme Court. And it's not at all clear to me about when it is that the Supreme Court will follow one theory and not the other. Do we have the institutions that we need? Do we have the federalism that we need? Now I'll talk a little bit about the Senate reform reference. Again, the Harper Senate reform agenda, a key component of this agenda was the proposal for consultative elections. That consultative elections will be held either across the country, different possible provincial schemes, but the whole point would be that Canadians would weigh in on effectively what the list of nominees would be to the Senate. The Harper government's argument was that this is really informal constitutional change. This is constitutional change which may be consequential, may well be important, may well change the way that things happen in Canada, but it is still informal. That is operated through parliamentary conventions. And so completely constitutional and completely the way that we conduct a quiet constitutionalism in this country. The Supreme Court of Canada mounted this argument in response, rejecting this convention-based argument, that consultative elections are not really consultative elections, that non-binding is only a mere technicality. The word non-binding actually means binding, that non-binding means elected. That what would occur with non-binding, putatively non-binding elections is actual change, actual de facto political change. And that this political change would be a fundamental change to our constitutional architecture. And because a fundamental change to our constitutional architecture really is formal change, engaging our formal amendment procedures in the Constitution. To me, this line of logic, this line of reasoning, is highly problematic, absolutely highly problematic. It is not even, to me at least, a logical argument. And I think there's a lot of downside here. That here we have a really important mechanism for how we change our institutions through convention that says that federalist principles or other principles that we have, sometimes we actually do make choices between them, and Parliament will choose. That as Parliament stands in the House, that it will rise or fall on the degree to which Canadians agree or disagree with this idea that a democratically legitimate Senate is a fracturing of our Constitution. So I don't really like the Senate reform reference, as you might have gathered. Do we have the political institutions that we need? Do we have the federalism that we need? I have no idea whether an elected Senate would work or if it would not. I'm not here to champion the elected Senate as a reform proposal, but I believe it to be within our constitutional structure to allow a prime minister to propose it and to allow him to live or die by that proposal in the House. My last comment, or set of comments, to the question, do we have the institutions that we need? Going back to the idea, do we have the institutions that will enable our elected political people to bargain, to do the bargaining that needs to be done to make this complicated federation work? And I'll point now to the work that's done by a PhD student of mine, Tony Imbrogno, who's in the room. He's been working on the question of why does Canada have under-institutionalized heads of government meetings? Why are heads of government meetings ad hoc, personality-driven? Stephen Harper didn't do them. Maybe Trudeau will, maybe Justin Trudeau will, but there is no Council of Australian Governments in Canada. There is no top-level summitry institution where politicians can make those hard bargains across sectors, across issues. And so when we talk about a pipeline, when we talk about Energy East, when we talk about the Northern Gateway, there's no space for no institutionalized space for the Prime Minister to engage in multilateral negotiations, to tie those kinds of decisions with others, like electricity transmission towers, like regulation of other issues in the economy. It doesn't exist. And so in that respect, perhaps, we don't have the federation that we need. So on that happy note, I'll let the other Professor Schultz weigh in with what I understand to be very tough remarks, and I assure him that we are ready.
Thank you. Now, before I electrocute myself, Call home, it says. Anyway, I thought I'd go into my Charlie Rose format and ask you to turn off the lights so that I can't see anybody and just look right into the faces of the two panelists. But in fact, because of the extended coffee break, we don't have as much time as we have. So I'm just going to because I wanted to talk a bit, get two panelists who are here to talk a bit about Laurie Turnbull's work about Parliament. The book, and I'm very sorry she wasn't able to make it, she co-authored this book, Democratizing the Constitution, Reforming Responsible Government, which won the Donner Prize and won the Smiley Prize as the best. And I thought she frames the debate, she and her co-authors frame the debate very importantly. But I want to talk about a couple issues that are raised from her work, but more that they're raised from Jim Mallory's work. In fact, the last piece, I think, the last major piece he published in 1985, that there are a few students of mine in Poly 221 who are here will recognize, because since 1992, when I took over this course, it is the first thing they read, and it is the last thing they read, and it gives rise to the most important questions in the final exam. But one of the things, Mallory, I want to talk about Parliament, and Andrew has talked about Parliament and its deficiencies. And Mallory quotes, and I think approvingly, a quote from Robert Stanfield, that he says, "It is a wonder that the House of Commons does not destroy the minds and souls of its members." And that has also been a quote that's been on my introductory Canadian government course. My question to the two of you would be, why do so many people voluntarily run for office? Given that they know this, I mean, this is not limited to a few narrow academics. And again, Andrew mentioned the book, and you know, I used to be 6'2". I was almost Watson's height, except I started carrying books in a backpack, and I'm now. But the book that Andrew mentioned, without giving the title, is one I recommend to everyone in this audience, and I use it again. It's called The Tragedy in the Commons. Former members of Parliament speak out about Canada's failing democracy. And in fact, they give all of the detailed evidence of why their souls should be destroyed, and their minds of members of Parliament. My question to the two of you, just to start off, is, given what we know, the voting machines, the trained seal mentality, etc., why do thousands of intelligent, civic-minded, well, most of them intelligent, civic-minded Canadians voluntarily try to put themselves in that position? Christa, would you like to? I know you don't have a degree in psychiatry.
Okay, well, I can only speculate, not ever having been a member of Parliament or any provincial legislature. I do wonder sometimes if we just don't really understand the parliamentary system, and it seems silly, but if everybody took perhaps Poly 221, it would be different. I think it would be very difficult for your average Canadian to discern the really critical role that Parliament is to play in our political system. It's not something that comes forth obviously when you watch the political sphere, as Mr. Coyne so ably pointed out. I don't know why, I don't understand why there would be many rational reasons for why members of Parliament would not act so, but I wonder why we have such little understanding of Parliament itself as the central institution of our collective space.
So your answer is the fault is not in our stars, but in our teachers. And I'm not going to take that responsibility. Jim, do you want to try it?
Yeah, I mean, I would sort of disagree with what Rick is saying. I mean, it's not surprising he supervised my dissertation, and that's part of the
survived
relationship.
it.
But I'm not, I think there is a fundamental misunderstanding on the role of those who run what their role will be. And if we think to the book, Mr. Smith Goes to Ottawa, which is sort of a precursor to the tragedy of the Commons, and it was a study where an individual interviewed a series of members of parliament who were leaving, and many of them acknowledged that they were very misguided about what the role was. And that sort of explains the high rate of turnover. And in the book, I mean, many of these members of parliament were saying that they didn't feel like they really understood the job until about the third year of their mandate. And at that point, they had to decide whether or not to stand for re-election. And one thing that characterizes the Canadian Parliament is the high rate of turnover if you look in comparison to the British Parliament. And I gave a lecture years ago, and I used the quote from this book that said in the Canadian case, and one of the reasons why the Prime Minister is so dominant is that the Prime Minister faces a transitory backbench, whereas in the United Kingdom, the Prime Minister faces an entrenched backbench. So I'm not sure that there is an understanding of what the role is until individuals get there, and I would argue that the high rate of turnover is a realization of what that role is, which is, going back to the quote by Stanfield.
Thank you. In Mallory's article, and it goes back, Andrew referred to this. I would have pushed him on it if I was examining him, or examining. But Mallory makes the quotation statement, which is unique and I can find in the literature on Canadian politics. He says checks and balances existed in our system's early days, but have been eroded or lost their persuasiveness. The interesting reason why I say this is so unique is that there's a dictionary of Canadian politics that's used that does not even have a mention of checks and balances as a Canadian concept. The question I want to ask Jim first is, in terms of the courts, is that the courts have been embraced by many Democrats, small d, okay, as replacing the checks that were there. When Jim was writing this in '85, and he was one of the authors of one of the first articles on judicial challenge under the Charter, the Operation Dismantle, but he was writing this just before, in fact, all of the. What do we think about the health of democracy when an unelected body, such as the Supreme Court or lower courts, are embraced by academics and citizens as the most important check in a healthy democracy?
Well, I would invoke Professor Mallory's quote in the article that you're talking about, where he says, "Are we victims of system failure?" And I would think the embracement is indicative that there's the widespread feeling of that for the reasons that Andrew Coyne mentioned earlier. But I'm actually someone that cautions against understanding the Supreme Court of Canada as a very powerful political actor. And that's part of the sort of the debate now, that the Supreme Court of Canada makes a decision. It's taking away the will of Parliament. Well, the will of Parliament has been taken away a very long time ago by the Cabinet. And so I'm not particularly concerned with Supreme Court's ruling against the decisions of Parliament, because in effect they're not the decisions of Parliament. They're decisions of the ministry. But on a broader note than that, and this is something that I'm working on right now, we have to recognize that the courts are essentially implementer-dependent institutions, that their decisions are reviewable. And one of the examples that I talked about in my presentation was the Insight decision, where the Supreme Court of Canada said that if the health benefits can be demonstrated, the Minister of Health must not deny the establishment of a new facility. Well, the Harper government's response was Bill C-2, which created 27 conditions on which a new facility must be established. And many of the stakeholders that were interested in establishing these facilities are on record as saying the government created an onerous legislative framework that none of them can satisfy. So it goes back to the question about the courts. I don't think the courts should be embraced to the degree that they have, and I think that's the value of Professor Mallory's work, which he called upon the need to reform, but reform within the parliamentary tradition. And I think, again, my first book was called Governing with the Charter. I'm writing a follow-up now called Confronting the Court, which I think is the experience of the Harper years. But it says something, perhaps, that the courts do not represent the final word and should not be embraced to the way that they have by so-called Democrats.
Thank you, Drew. Krista, last question, because then I think our time is shorter, and I'm the last person.
Yeah.
That's the point. I'm the last person to stand between you and my glass of wine. But you mentioned the Senate reference.
Yes, I did.
Okay, and you said you agreed with the Harper position. I must say, just as an aside, I disagreed with it because the notion of an elected Senate meant that I would never, ever be able to get to the Senate. But
You may surprise yourself.
no, the only election I won was to be as chair of the Department of Political Science, and I rigged that election. But
You're unopposed.
yesterday, yes, this is side talk. Yesterday, William Thorsell in the Globe and Mail was in high dudgeon, and I checked with my thesaurus to see that I really understood it. And the title of his article is "Independent Senators Are a Threat to Our Parliamentary System." You've talked about the value of them, Jim, that if this is carried through and extended to a larger number of them. Would you agree, Krista, with Thorsell's comment that they are a threat, that they should, in fact, be as docile as the partisan senators are supposed to have been? Your degree depends on your answer.
Yeah. I already have it. Okay, so I have a couple of thoughts going through my head. According to the Supreme Court Senate reference, what's the value that the Senate is to play, right? What is it there to do? It is a chamber of sober second thought. So if independent senators achieve at least this function, the Supreme Court has no difficulty with this, right? This is exactly what it's supposed to do. The next question is, well, what is the point of having a chamber of sober second thought if it is not to have any influence? My answer there is, well, there's nothing in the Constitution that regulates this, right? There's no tie-break rule. This is all regulated through convention, and so I think it should continue to be. I think that we should actually consider ourselves to be grown-ups and adults, and give ourselves some cred to work this out. That allow the Senate to flex its muscles. We'll see how far it can go, and maybe we might like it, and maybe we don't. But that the political system can actually try to figure this out.
Thank you. I've always loved that expression, a chamber of sober second thought. Does that mean that the House of Commons is the chamber of the drunken first thought? That's not a question. That is. Do we have time for a few questions from the floor?
Maybe two.
And I don't examine, grade the questions from the floor.
No follow-ups.
Yeah, okay.
It's very draconian, Will.
I think my question probably touches on both your excellent presentations, but I think probably is more directed at the first, which is the idea that the House of Commons should subject itself more to scrutiny for the will of the judiciary, and whether that relationship goes both ways. I think in light of the last decade, I think many would argue that the Supreme Court of Canada has in some respects become a quasi-political actor. You can look at this Chief Justice attempting to dissuade a sitting Prime Minister from an appointment, their use of a complete hypothetical to strike down law in R versus Nur, and their use of convention for consistently having 9-0 decisions to basically suppress any dissent within their own body. And so whether in light of that, it's time for the Supreme Court to also let that relationship of scrutiny flow the other way.
Well, I guess, the point of my presentation was not that the House of Commons needs to be scrutinized, but but the government and its bills need to be scrutinized. And that's one of the limitations I identified in my presentation regarding the current reporting obligation. I'm not calling for an empowerment of the Supreme Court. I think it has the existing powers that it needs under Section 24 of the Constitution, the Charter of Rights, and so forth. But what I'm calling for is and again, this is all dependent on the political will of the executive, subjecting itself to greater scrutiny, which I think was missing in the last mandate. And the bills that I've identified, I don't believe they're constitutional. But the government is under no obligation, except for a badly written provision of the Department of Justice Act that requires it to report inconsistencies. As I said, it's prevented from doing so. So my attention would be more to focus on changing sort of the mechanisms of reporting. And I'm being told that the House of Commons Standing Committee on Justice and Human Rights is presently considering mechanisms to identify and flag charter issues for potential debate. And so I would argue that's where the resources should be focused on.
Thank you.
Last word.
In the United States, for the last number of years, there's been an ongoing debate about constitutional issues, whether one agrees with Antonin Scalia that the Constitution is holy writ, or whether one adopts more flexible living tree approach, which seems to be more based on our models. And I'm wondering if the two panelists can perhaps make a connection between their views on what our constitution and court system is on the basis of either one of these overwhelming ideologies.
Do I have a theory of constitutional interpretation, in other words?
Yes. In other words, how do you view Canadian constitutional issues in light of that debate that seems to be a classic problem in legal matters?
Constitutions need to be able to change, right? They need to be able to adapt. They need to move with the times, but not infinitely so, right? So this is the challenge of constitutional interpretation. If it moves too much, then there's no point in having a constitution, because we're supposed to bind ourselves across generations. My question is, well, what are the different ways in which the Constitution is to adapt? The courts obviously have a huge role to play in how they interpret the text, the position they take towards the text. What I want to bring back to the table is a very old-fashioned argument that the Constitution also very importantly grows and adapts through convention. And when the Supreme Court makes decisions that hobble the ability, just hobble or call into fundamental question that point, that basically argue that convention is a way to sabotage the Constitution rather than a way to reform it or to renovate it. That's when I have a difficulty, because it says something about the relative role of the court versus political actors as parties in our constitutional structure. So, I'm fine with a living tree analogy as long as we can understand or consider politics to be part of that living tree, and that the courts are not the sole arborists in our constitutional space.
Thank you, Christa. I will turn it over, but of course, not immediately. I think the purpose of this panel, and it would have been enhanced as well with Lori, is to in part to show to the Mallory family, but also to this larger community, that Professor Mallory's concerns and his lasting contribution to Canadian scholarship, our understanding the constitution of political actors, I think is exemplified by Christa and Jim. Demonstrates that scholarship and that engagement that Jim Mallory had throughout his life as a scholar. He wasn't a removed academic. He was an engaged academic in important political constitutional questions. I think we can see from the presentations we've had today, that scholarship is in very strong hands with Jim and with Christa. So please join me in thanking them. You're to decamp. No, they're good.
Well, I always wondered what you political scientists did for a living. I thought you just read newspapers and stuff, so this is very impressive. No, it was really, really a good panel, very thoughtful. No, a very impressive, thoughtful panel. I'm just going to thank a few people and then call on someone for some concluding words. Again, I want to thank you all for joining us today for the 2016 J.R. Mallory Lecture. This is an annual event. It's not always so big with so many speakers, but it is an important part of the MISC calendar. So please go to our website, www.mcgill.ca/MISC to follow next year's announcements. Thank you so much to Andrew Coyne. Thank you very much to James Kelly, who's an old friend of MISC's. You were a visiting fellow, I know, at one point. Christa Scholtz, who, among other things, sits on our Indigenous Studies Program Committee and contributes a great deal to that. And Rick, where are you? Oh, okay, sorry, who from the very beginning of MISC has been absolutely essential to so much of what it's done. Thank you for your support and precious collaboration in organizing the event. We'd also like to thank the Dean of Arts Development Fund for its financial support in making this event happen. I'd also like to extend our gratitude to the sons of J.R. Mallory, Charles, whom you've heard from, and his wife, Dorothy Levine, from Ottawa. Jim and Linda Mallory, we'll be hearing from Jim in a second, who've come all the way from the UK, who are here today. Their generous contributions over the years help us to continue this important lecture series. And I'd now like to introduce Jim Mallory, who is the older son of Professor James Mallory and Frances Mallory. He was educated at McGill with a BA in History and Political Science. He's lived most of his adult life in the United Kingdom and is married with 2 daughters. He worked as an editor in reference book publishing and in journalism and was an active trade unionist. And I find this very cool. He was elected as a local councillor in Lewisham Borough in southeast London, where he served in various positions, including chair of the Education Committee and leader of the council. So please join me in welcoming Jim Mallory.
My task is to conclude and primarily to thank people, but I have traveled 3,000 miles to get here, so I hope you'll permit me to indulge me with a few personal comments as well. And I'm also the only, as Will said, I'm probably the only practicing politician, albeit a local councillor, who's addressed you today. So I've absorbed some of the things that have been said about politicians. First, just to say in passing, to Andrew Coyne, not everything is as perfect in the United Kingdom as you sometimes applied. The chaps don't behave terribly well most of the time, and although the committee system is better, that the scrutiny committee system is better than it is here, it has a long way to go before it's perfect. And thanks both to Jim Kelly and to Christa Scholtz for their contributions. The courts, of course, have changed a lot in Canada since I took Political Science 221, but it was very useful to me to hear some of that Britain could do with a charter, a proper charter of rights, so there are lessons 2 ways there. And to Christa Scholtz, I've been a Federalist from birth, or almost from birth, certainly from elementary school when I sat at the Government of Canada Course 221 at the Mallory dining table. And I've latterly written in British journals that it's time to use the F word in Britain, federalism, as Scotland seeks to move away. There are very few scenarios that will save Britain from breakup if some sort of properly constituted federal structure isn't adopted, in my view. As I said, the Mallory dining room provided some of the lessons. When Charles and I were in elementary school, we learned about King Byng and the Governor General's discretionary powers, and we also learned about the pipeline debate and the undermining of parliamentary scrutiny that perhaps contributed to. My father was a very high achiever. His generation was the first to go to university in his family, and he expected the same of his sons. And I have to confess, I think we were a profound disappointment to him, as you do between generations. And I think both of us probably went through a phase of criticizing him for being a traditionalist and small c conservative in his views. And I think both of us have experienced latterly how right he was about so many things as we grew up in our respective roles. One as Charles as rising to be a senior civil servant, and me to being a senior local politician, albeit a long way away. But he did know a lot about UK politics too, so some of my grounding in UK politics was learned at the dining room table. And I think he was eventually reconciled to us because we practiced the arts of the things that he was so expert in being a student of. But I suppose my regret, because you'll know, of course, that I think it was mentioned that he died in 2003, so he didn't have the joy of experiencing the Harper government, which would have given him so much opportunity, what with the things like the omnibus bill and the proroguing of Parliament. Think of the discretionary powers of the Governor General in those instances, because it would have given him lots of opportunity, even in his dotage, which he was not when he died, to have views which would, I imagine, still be relevant to today. So the thanks that I have to give are not just to our speakers, and thank you very much indeed, but to Rick Schultz, who did so much to pull the thing together, along with Will Shaw, Joanne Bilodeau, Clélia Danger, I hope I've got that right, and Monica Dedich, all of whom worked really hard because the logistics were quite difficult. It was originally scheduled for the faculty club. Most of you are probably benefiting from the fact that it's now in a hotel when the date was changed on us. And we are very, very grateful to you all. So, and thank you particularly as well to the audience. There were some really sharp questions. They were real questions this time and not speeches, in helping us to observe his legacy, my father's legacy, and to honor his memory. So thank you very much indeed.
I just briefly want to repeat the thanks to Monica Dedich and Clélia Dengue, who are there, the wonderful MISC team, Joanne Bilodeau, who may be in there, and invite you all to join us for a glass of wine and perhaps something to eat. Yes, so thank you.